The following program is suitable for general audience of any age.
Tonight, we discuss the legal foundations of murder and suicide. How have the laws relating to this area developed over time? A very good evening and thank you for joining us on yet another episode of Law, Land and Liberty here on Other Derana News Channel, where we bring to you key legal concepts and break it down for the layman. Now, today's topic is something that a lot of individuals are colloquially familiar with but haven't really gotten into the depths of the law. Specifically, we're going to be talking about murder, homicide and also suicide related cases. Specifically, how exactly they are distinguished and what exactly we can learn as the common man and the layman to help distinguish these areas. Now, to speak about this, we have someone that's not a new face on our program. We're very glad to welcome back onto the show Mr. Lakmal Ratnayake, attorney at law. So thank you so much for taking the time to make it here to the studio once again. We really appreciate it.
Thank you.
And a bit of an introduction, of course, Mr. Lakmal Ratnayake is an attorney with over 22 years of experience who specializes in criminal law and is also a lecturer at Sri Lanka Law College and the former chairman of the NICD, the JCT Limited, CWE, SLPMCS, and of course a former director of Sri Lankan Airlines, as well as a former director of Sri Lanka Ports Authority, HIPG, CICT, and many more. Now, the interesting fact is we are going to be getting into this topic with a lawyer that's specializing in criminal law. So specifically, we will be able to get maybe a little bit of a practical experience as well with how these kinds of cases are handled in the court system. Here's how we're going to be, diving into this topic. First, we'll be getting into the very basics, how exactly murder, homicide, suicide is actually legally defined in Sri Lanka in terms of the law. Next, we'll be getting into the practical context, the current context, specifically with the modernizations of technology, how it has affected this area of the law. And finally, we will be talking about suicide specifically and how exactly it's judged under Sri Lankan law.
Hello, my name is Salman and I'm a football referee. My question is on fundamentals. How are crimes like murder judged under Sri Lankan law?
All right, well, without any further ado, let's get right into this discussion. We have a lot to get through. Thank you very much once again, sir, for taking the time out of your busy schedule. We really appreciate it. Now, before we get into any legal technicalities or terms, I think it's important for us to give the layman a little bit of contextual understanding as to what murder is. Now, culpable homicide and murder is an area that is, these terms are used very interchangeably. Specifically from the law's perspective, from a legal perspective, what exactly differs these two concepts, from being one and the same?
First of all, thank you, Anuradhi, for inviting me again back to your program. So, as you mentioned, culpable homicide and murder are both offences are very clearly defined in the Sri Lankan law. And culpable homicide is defined in section 293 of the Penal Code of Sri Lanka, and the definition for murder is clearly defined in section 294 of the Penal Code of Sri Lanka. The punishments for culpable homicide and murder are also very clearly stated in section 296 and section 297 of the Penal Code. So, culpable homicide and murder, every murder is a culpable homicide, but every culpable homicide is not a murder. So, there could be culpable homicide not amounting to murder, and section 294 also very clearly defines 5 exceptions as to where culpable homicide does not become murder. So, if I may read from the Penal Code, section 293, the definition is whoever causes death by doing an act with the intention of causing death or with the intention of causing such bodily injury as it is likely to cause death, or with the knowledge that he is likely by such act to cause death, commits the offence of culpable homicide. Now, there are few explanations given in this. Explanation 1 is a person who causes bodily injury to another who is laboring under a disorder, disease, or bodily infirmity, and thereby accelerates the death of that other, shall be deemed to have caused his death. Then explanation 2, explanation 3 goes on. So if one goes through the penal code, one can get a very clear understanding of what these explanations mean. Then section 294 describes murder, and then 294 talks about the exceptions where murder will be culpable homicide, culpable homicide will not amount to murder when the facts fall under any other exceptions given in these 5 exceptions. So exception 1 would be culpable homicide is not murder if the offense whilst offender whilst deprived of the power of self-control by grave and sudden provocation causes the death of a person who gave the provocation, or causes the death of any other person by mistake or accident. So grave and sudden provocation is a situation that we face in in lot of cases where there is a murder charge involved. It has to be grave, Anuradhi, and sudden. The provocation has to be grave and sudden. It cannot be a pre-planned, premeditated provocation unless there are certain exceptions, like where there is cumulative provocation, where I would come to cumulative provocation later on. There are a lot of authorities on that also. So in grave and sudden provocation, there is no premeditated, pre-planned act. It is a sudden thing that happens where you lose your control, self-control, and commit an irrational act. In a situation like that, most of the time, even if initially a murder charge is preferred, subsequently, after consideration, most of the occasions, if there is evidence, if there is factual proof to establish grave and sudden provocation, the charge would be amended, and most probably, after trial, the accused will be convicted for culpable homicide, not amounting to murder. So that is exception number 1. Then there is another exception, exception 2, where the person, the accused, acts in excess of his right of private, exceeds the right of private defense. So as you know, Anuradhi, private defense is your right. You know, you have a right to private defense, and it's not an offense. If you commit an act in your defense, it's not an offense. But if you exceed that right, say I come to hit you and you have a weapon and you shoot me, that is excessive. So you exceed your right of private defense. So in a situation like that, still it is not murder, but culpable homicide, not amounting to murder.
Right.
Then exception 3 is where the penal code very clearly states that culpable homicide is not murder if the offender, being a public servant or aiding a public servant acting for the advancement of public justice, exceeds the power given to him by law and causes the death by doing an act which he in good faith believes to be lawful and necessary for the due discharge of his duty as such public servant, and without ill will towards the person whose death is caused. So this is the third exception, and of course the fourth is also a very common exception, that is the sudden fight, where again there is no premeditated act, it is not pre-planned, there is no conspiracy, and a person suddenly gets entangled in a sudden fight with a few people or with another person,
right,
and again commits an irrational act, and then a person succumbs to the injuries suffered in the course of it. Then again this exception would apply, and culpable homicide would be not amounting to murder in a situation like that. Exception 5 would be culpable homicide is not murder if the offender, being a mother of a child under the age of 12 months, causes its death whilst the balance of her mind is disturbed by reason of her not having fully recovered from the effect of giving birth to the child, or by reason of the effect of lactation consequent upon the birth of the child. So the 5th exception would be where a mother of a child basically causes the child to die, and this happens due to the mental imbalance she suffers due to the childbirth and also lactation, breastfeeding. So that will be considered as a situation of culpable homicide not amounting to murder in law. So these are the 5 exceptions. So as I told you earlier, if a person is convicted for an offence under section 293, that person can be punished under section 297. And if a person is convicted for an offence defined under section 294, that person can be punished under, will be punished under section 296, and the only sentence that can be given under 296 of the Penal Code, Anuradhi, would be the death sentence.
Right.
So this is the difference between the two.
There is a drastic difference, and provided upon those exceptions, we can find a stark difference. Now, there is an area that is quite curious for the layman as well, which is suspicious deaths. Now, if you could help us understand, sir, especially upon the reporting of a suspicious death, what exactly is the process with which it is handled from the police to the courts? Could you walk us through maybe the investigation and also the court's process, what exactly the magistrate does in this situation, the Attorney General and so forth? How exactly does the law apply in this area?
Yeah. So in cases of a suspicious death where murder is alleged, the procedure that would be adopted is similar to any other crime where initially, but there are drastic differences, initially the facts will be reported before a court of law, that is before a magistrate's court, but before that, as soon as a crime is registered or informed to the nearby police or to the police which has the jurisdiction, or through maybe a 119 call or a 118 call, as soon as the police receives the information, they would immediately commence an investigation, Anuradhi. So what the police would do is initially they will visit the scene of the crime. And they will try to identify the evidence, and they will commence the investigation immediately. They will try to identify the evidence that is available. So as you know, Anuradhi, there are mainly 2 types of evidence: direct evidence and circumstantial evidence. So direct evidence would be the recording of the statements of the witnesses under the provisions of the Criminal Procedure Code, and finding out more details and preparing basically a sketch of the area, and so on and so forth. The circumstantial evidence would be collection of blood samples, and to see whether there is material to be sent for the government analyst department for testing, then the DNA reports, whether there is any material. So the police SOCO unit will be will be asked to investigate and collect evidence to that effect, and also they will look at now of the present day, they would look at the CCTV footage, phone records of any suspicious people to see whether they were in the vicinity. They can, by taking the tower reports and all that, they can do investigations on those lines. So all this will be done initially. So once this is done, a summary of evidence of whatever they have collected, and the summary of statements will be produced by way of, initially facts will be reported by way of a B report, then subsequently they will file further reports on the collection of evidence and the progress. So here it's very important because the magistrate will be overseeing the investigation, and the magistrate, where the facts are reported to, would be making orders, Anuradhi, that are required, say, to issue warrants or to give various orders to get details further. So there will be judicial orders that will be given for the police to do their investigation properly and to enhance the required facilities to help the investigation. So after that, what happens is the inquest will commence. The post-mortem will also be conducted. So there will be a JMO performing the post-mortem, and then the cause of death will be ascertained. Then the inquest will also proceed simultaneously, and then evidence will be led, whatever that is initially available. And then they will try to identify, before that, of course, they will try to identify the suspects.
Yes.
So they will try to identify the suspects, and when the suspects are identified, necessary arrest would be made. So when a person is arrested as a suspect in a murder case, Anuradhi, that suspect will have to be produced before the magistrate's court. And as you are already aware, bail will not be considered for a murder suspect before a magistrate's court, because the relevant court that has the jurisdiction to decide on bail would be the High Court. That is very clearly mentioned in Section 13, if I'm not mistaken, Section 13 of the Bail Act, Act number 30 of 1997, where it clearly says that for any offence that would be punishable with death or life imprisonment, the bail for those offences would be considered only by a High Court.
Right.
So accordingly, to seek bail on behalf of the suspect, one would have to make a bail application before the relevant High Court that has the jurisdiction. So after all this, now the investigations will conclude. Once the investigations conclude, the prosecution will commence the non-summary inquiry.
Right.
So then by the time the non-summary commences, the post-mortem will be completed and the inquest will be completed, and then the non-summary would commence. So once the non-summary commences, the evidence that is already available, that is recorded, the statements of the witnesses would be led before the magistrate. So once the statements are read out and the evidence is recorded, the witnesses will be inquired to know whether they want to make any changes to those statements or amendments, or whether they want to make whether they want to repeal any parts of it. And if they don't want to make any changes, it will be recorded. Otherwise, if they want to make those changes, would be recorded, and those rectifications will be made. And then the non-summary would be concluded. So once the non-summary is concluded, Anuradhi, the magistrate would have to either commit the case to the High Court if the magistrate is satisfied that there is sufficient evidence for the case to be committed to the High Court. If the magistrate is not satisfied, if the magistrate is not satisfied with the degree of evidence that is available, if the magistrate the magistrate has the discretion to discharge.
Right.
So if the case is committed, when the case is committed to the High Court, the magistrate will direct the record to be sent to the Honourable Attorney General to prepare the indictment.
Okay.
So once it goes to the Attorney General has the discretion either to indict or to still discharge, even if the magistrate has committed the case to the High Court. Even in a case where the magistrate has discharged, still the Attorney General has, under the criminal procedure, the discretion to, even if there's a discharge, he can still indict. And once the indictment is forwarded, the accused will be summoned again if he's on bail. If he's in remand, he will be summoned from remand. And if he's on bail, if he or she is on bail, then the indictment will be served, and the pre-trial and the jury option, and then the trial will commence. and the matter will be concluded after leading of the prosecution evidence as well as the defense evidence. So then order will be, judgment would be given.
That's almost the entire lifespan basically of how these kinds of cases are conducted, very summarized proceeding of events, but still essentially the areas of which we can see the key points of how the court system actually handles these kinds of cases. Now, we do have to get to some practical examples as well, and what we see in our current context, especially moving through our court system at the moment, but we do have to take a short commercial break before that. You're watching Law, Land and Liberty here on Other Derana News Channel. We'll be right back after this, so please stay tuned.
Hello, my name is Anjana and I'm an undergraduate in the field of data science. My question is on practicalities. What are some recent developments in law surrounding homicides?
Welcome back to Law, Land and Liberty here on Other Derana News Channel. We're in conversation with Mr. Lakmal Ratnayake, attorney at law. We just got done discussing the very fundamentals of a murder and culpable homicide. Specifically, we just finished very quickly the sequence of events as to how exactly these kinds of cases, especially when it comes to the investigation of suspicious deaths, moves through our court system. Now, we have to get to the practical aspects of it. Thank you very much, sir, for the previous segment. I believe while it is a vast area, we're trying to cover as much of the essential parts as possible, and this is something that I'm sure the layman would want to better understand, specifically practical examples when it comes to how Sri Lanka's courts illustrate these kinds of areas, especially when it comes to the exceptions. Now, as you mentioned the 5 exceptions previously, I'm sure we don't have time to go through all practical cases for all of the exceptions, but something that stands out to you, especially that you believe would be knowledgeable for the layman to know, especially in our current context.
Yes, Anuradhi. Now, when it comes to culpable homicide not amounting to murder, when one visits the high courts of Sri Lanka, you find a lot of cases where you would find these exceptions being applied, where the exceptions would become relevant to the facts of those cases. So, except for a few cases where I think these contract killings and underworld involvement is involved, where none of those exceptions would apply, and it will be just the murder charge, especially in the provinces. You will find a lot of cases where those matters fall under either one of these exceptions. Sometimes it is provocation, sometimes it's cumulative provocation, or otherwise a sudden fight. So then exceeding the right of private defense. All these situations apply to a lot of cases. So in my experience as a lawyer, I have come across so many cases that had the applicability of the general exceptions. So as it is explained, as I explained to you earlier, so section 294 very clearly explains the 5 situations that where culpable homicide would not amount to murder with grave and sudden provocation, then exceeding the right of private defense,
Yes.
Then where a public servant acts in good faith, exceeding his powers, commits an offense and a person dies as a result, and also a sudden fight, and also mother of an infant
Yes.
committing causing the death of the child would be the situations that would be applicable. Now, one of the main cases that I would like to discuss is the case of Kumara versus Attorney General, where it's reported in the Sri Lanka law reports. It's 2003 1 SLR, page 139 if I'm not mistaken, where there was a charge of murder against the accused, and subsequently the murder charge was amended to a charge of culpable homicide not amounting to murder. and the accused pleaded guilty to the charge under section 297 of the Penal Code, and he was convicted and sentenced. So the sentence was 7 years rigorous imprisonment, which in law can be imposed because, as I mentioned to you, the only punishment for section 296 would be the death sentence. But for section 297, the punishment would vary depending on the circumstances and the other factual matters that has to be considered in mitigation. So, for culpable homicide not amounting to murder anuradi, there is no minimum mandatory term. So, there is no minimum jail term. If court wants to impose a suspended sentence under section 303 of the Criminal Procedure Code, still the courts can impose, especially the High Court, can impose a suspended sentence for culpable homicide not amounting to murder. That is mentioned clearly in section 303 with regard to suspended sentences, and also in section 13 of the Criminal Procedure Code, where it is very clearly mentioned that the High Court has the power and the discretion to impose any order stipulated by law. So, under section 303, suspended sentence is something stipulated in law. So, the courts can impose a suspended sentence. So, what happened in this case, in Kumara versus Attorney General, was that the accused pleaded guilty. He got a 7 years rigorous imprisonment sentence, and he appealed against the sentence. And in appeal, the discussion was whether the sentence was fair or whether it was excessive. So, the Court of Appeal decided in Kumara versus AG that the sentence was excessive, and they suspended the sentence. So, in this, the Court of Appeal has laid down the importance in this judgment of a suspended sentence, even for the offence of culpable homicide not amounting to murder. If I may read just the part regarding the sentence, it says, the order very clearly states, by the way, this is a judgment by Justice Edri Surya, a suspended sentence is a means of re-educating and rehabilitating the offender rather than alienating or isolating the offender. 2, no offender should be confined to in a prison unless there is no alternative available for the protection of the community and to reform the individual. Number 3, imprisonment has an isolating and alienating effect on the family of the imprisoned offender because of the hardships they are faced with during the imprisonment of one of the family members. Suspended sentence, with its connotation of punishment and pardon, is supposed to have interrogative powers. The offender is shown that he has violated the tenets of society and provoked its wrath, but is immediately forgiven and permitted to continue to live in society with the hope that he would not indulge in that form of behavior again. So, these are a few things that the court has considered in converting the custodial sentence into a suspended sentence. So, at a time of pleading guilty in the first instance for a charge under section 297, the court would always look at the character of the accused, the remorse he is showing, his age, the antecedents, whether this person has previous convictions or pending cases, all those things will be considered in sentencing. So, all this would be applicable for a person who was convicted either by pleading guilty or after trial, who is convicted for an offence under section 297 of culpable homicide not amounting to murder. But for murder, as I told you earlier, there is no other alternative but to punish that person with death.
The death sentence, yes. Yeah. And speaking of the punishment for murder, specifically the death sentence, so of course we are all aware that while we have death for murder in our Sri Lankan legal system. Executions are not something that have been taking place for quite some time now, for decades. When it comes to the practicalities of that area, exactly what kind of sentence does an individual that's convicted of murder receive in our present day? And as you mentioned, how does it differ from the sentencing or the punishment that's received for culpable homicide?
Yeah. So I think I explained this briefly in my previous answer.
Yes.
So what 296 very clearly states is, I will read section 296, because whoever commits murder shall be punished with death. So there is no other alternative for a court that convicts a person for murder other than to commit him to death. There is no other alternative that can be considered.
Right.
So, but when it comes to culpable homicide, not amounting to murder, there is no such limitation in the legislation. There is no minimum mandatory term that has been stipulated. So, court has the discretion to grant a very lenient term or a very severe term also, depending on the facts and the mitigatory circumstances. So, in murder, what basically happens is, Anuradhi, now as you very clearly stated, though the death sentence is given, it has not been implemented in Sri Lanka now for a long period of time. And there is a school of thought that it should remain the same, and also there is another school of thought that it should be reintroduced. And there was a time, even in Sri Lanka, I think after 2015, there was a short period where there was a big debate that it should be reintroduced, and certain measures were also taken to as you know, you can consider it as a progressive step to reintroduce it. But then subsequently that all went down, because still the thought is that it should not be re-implemented again. So that is the thought process. So what happens is, a person who's committed or sentenced to death would be condemned, but he will remain in death row and serve a life imprisonment. So there won't be any chance of pardoning unless, of course, there is provision under the Constitution, but it's very rarely that something like that would be considered. So as far as now bail is concerned, for a person who's convicted for murder, there is no bail even if he appeals against the judgment and the sentence. So he or she will have to stay in remand and fight the appeal. Now, for a person who's convicted for culpable homicide, not amounting to murder, if that person he or she gets a custodial term and appeals against only the sentence, there is provision for appeal. Because unlike in a death sentence, where there is no bail, there would be bail for a person who gets convicted for an offence under section 297.
Yes, exactly. Now, before we go in for a break, there is an area that is quite curious that we would like to get some clarity on, then that is specifically relating to attempted murder. Now, this is a term that's heard quite often when it comes to the discussion of the subject around murder and death in general. What exactly is the legal definition or meaning of attempted murder?
Yes, so attempted murder is basically attempting to commit murder.
Yes.
The definition is very clearly given in section 300 of the Penal Code, where it defines the offence as well as stipulates the punishment for the offence. So the punishment also for attempted murder differs because in a situation when there are no injuries, the sentence differs from a situation when there are injuries on the victim. So if I may read section 300, it states that whoever does any act with such intention or knowledge and under such circumstances that if he by that act causes death, he would be guilty of murder, shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. And if hurt is caused to any person by such act, the offender shall be liable to imprisonment of either description for a term which may extend to 20 years and shall also be liable to a fine. So this is what I told you earlier, because now in a situation where there is no injury, the maximum term that would be applicable is 10 years. But in a situation where there is an injury, then it could go up to a period of 20 years. Because now, for example, as you know, Anuradhi, attempted murder, there are cases where there aren't any injuries. Say now I have an intention of killing you, and I bring a gun and I pull the trigger. But either the gun jams or I miss you, I miss the target. And then there is no injuries inflicted on you. In a situation like that, only a 10-year maximum sentence can be given against me.
Right.
But if I succeed and if the bullet hits you and you don't die, but then you as the victim, you suffer an injury, then in a situation like that, my sentence could go up to 20 years maximum.
Exactly.
So this is the difference
The key
in
difference.
sentencing.
Exactly, key difference between sentencing. We are running out of time, unfortunately, in this segment. We still have to get to the areas relating to suicide as well. But before we speak about any of those specifics, let's take a very short commercial break. You're watching Law, Land and Liberty on Other Than a News channel. We'll be right back with the final segment. Please stay tuned.
Hi, my name is Lakmal Ratnayake and I'm a business analyst at Otus2. My question is about the future. Can we expect amendments to this area of the law?
Welcome back to Law, Land and Liberty. We're in our final segment in conversation with Mr. Lakmal Ratnayake, attorney at law, in discussion about murder, culpable homicide, and hopefully, when we have the time to discuss it, suicide as well. So thank you so much for the previous two segments. We are unfortunately in our final segment, and so we're going through some of the most important areas. Now, when it comes to our current context, as we just got done speaking about attempted murder as well, evidence is something that is, with specifically technology increasing, it has been an evolving landscape consistently. DNA evidence is key now in any sort of situation considering murder or bodily harm. CCTV footage, mobile phones, the phone records, GPS data and such. Could you help us understand exactly how these kinds of evolving technologies impact murder trials and how prosecutors approach these kinds of topics?
Yes, Anuradhi. As I told you, Anuradhi, there are two types of evidence, direct and circumstantial. So, direct evidence, witnesses may lie, witnesses may exaggerate, but circumstances will never lie, and circumstances don't exaggerate also. So, for a prosecutor, it will be very advantageous if the prosecutor has lot of circumstantial evidence to support his case, rather than only relying on eyewitnesses. Because eyewitnesses, my practical experience is that, my experience in courts is that they try to sometimes lie, exaggerate, sensationalize. So ultimately that affects the prosecution's case, because the consistency is broken sometimes and there will be contradictions amongst the witnesses as well as with the statements previously made by those witnesses.
Yes.
So circumstances don't lie. And circumstantial evidence is very vital. And what I have observed is over the years, technology has advanced very rapidly. And now the investigators and the prosecutors have a lot of circumstantial evidence that they can make use of. For example, as you said, the DNA evidence, which is very difficult to be, challenged or contested. Then, of course, now the scene of crimes are normally visited by the scene of crimes officers unit, which we call the SOCO unit, so of the police department. So when they visit the scene of crime, they collect the necessary samples for DNA testing, for the government analyst evaluation. All that is done nowadays, and also, as I mentioned, there is CCTV footage, sometimes the phone records and the tower records of the locations of the deceased and the accused. So all this helps the prosecution in building up a very strong case. The burden of proof is to prove beyond reasonable doubt. So I think with these rapid developments and advances in technology, it has become easier for the prosecution to prove cases such as murder.
Exactly. And now a key area that when considering homicide cases in general is defense when it comes to mental illness, mental instability. Can you please help us understand how exactly before a court of law an individual will be working towards proving that there is mental illness and mental instability, especially to ensure the criminal liability is reduced? How does that work, sir?
So mental illness is a defense that can be taken by an accused who is accused of a offense, and even for the charge of murder it is the same. So section 77 clearly describes of the penal code, very clearly describes mental illness. No act committed if that accused is a mentally ill person would be an offense, and he is entitled to an acquittal under section 77. If I may read, yes, section 77 of the penal code, nothing is an offense which is done by a person who at the time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. So basically, Anuradhi, if you are mentally ill, then if that defense is taken up by the defendant or the accused, and if court is satisfied or the jury is satisfied, then he is entitled to a acquittal. The famous case which relates to this is, as you may know, the case of McNaughton, where in the UK, McNaughton was mentally ill and he was delusional, and he was thinking that the Prime Minister of England was going to assassinate or kill him. So then, in return, with his delusional thinking, he thought the only way to overcome that was to kill the Prime Minister. And then he attempts to kill the Prime Minister. As a result, he kills the Secretary. But it was found with medical evidence that he was delusional and he was mentally ill, and he got acquitted ultimately from the charges. So it has to be now, of course, established. If the defense is going to take that defense, that has to be established, especially by medical evidence, by calling for psychiatrists and medical evaluation. And of course, the degree of, according to decided authority, the degree of proof is not beyond reasonable doubt in a situation like that. It will be on a balance of probability that the accused would have to establish the fact that he or she was mentally ill, because so many considerations has to be looked into, like the lucid intervals and the other factors that would affect an accused person who's mentally ill.
Yes, exactly. We are running out of time, so we have to very quickly move on, even though there's quite a bit of area we can discuss when it comes to insanity as well. Moving on, so a very interesting area, especially when it comes to evidence, is the dying declaration. How exactly is it possible that the law allows these kinds of statements to be made by a dying person to be considered as admissible in court, even though considering, the situation, it could be considered as hearsay? How exactly is a dying declaration given that much weight?
As you mentioned, Anuradhi, hearsay evidence is not admissible as evidence in a court of law. So that is the prevailing law at the moment. Even our evidence ordinance clearly shuts out hearsay evidence with certain limitations. Now, the section that would apply for a dying declaration would be section 32 of our evidence ordinance. So a dying declaration is a declaration made by a person who's just about to die. So it's a declaration he makes in anticipation, mostly in anticipation of death.
Yes.
So normally the belief is that a person who's going to meet the Creator would not lie. So a person who's just about to die would not lie in his last moments. So it is a declaration made to a third party. So the third party would have to come and testify in a court of law as to the statement that was made by the deceased before his death. In a situation like this, it's very vital and critical that the court looks into the condition of the deceased, because the medical evidence has to very clearly establish that the accused was, the deceased was competent enough to make a dying declaration, because there are instances where doctors give evidence confirming the fact that there was no opportunity in a situation with the injury pattern that the deceased could have made a statement to a third party, because this evidence cannot be cross-examined because the person who made the statement is dead. So it cannot be challenged.
Yes.
So in a situation like that, it has to be very clearly established that the deceased was in a physically capable, physically and mentally capable position to make that statement.
Right.
So this is very vital in considering and evaluating a dying declaration.
Exactly. One final question before we run out of time completely. Very quickly, sir, if you could tell us exactly how and why suicide, which was considered criminalized a long while ago, is now decriminalized. What exactly is the thought process behind that? What prompted this legal reform? As a final question, sir.
Yeah, suicide was a criminal offense. Attempted suicide also was a criminal offense, and Section 302, if I'm not mistaken, of the Penal Code was the section that was dealing with suicide and attempted suicide. Now, the present day, this section has been completely repealed, Anuradhi, from the Penal Code. So it is not an offense anymore, because I think the thinking behind that was that it's very inhumane for a person who has attempted to commit suicide again to be prosecuted and charged and punished for attempting suicide. So Section 302 has been repealed. However, Section 299 still remains. So aiding and abetting a person to commit suicide still remains an offense in Sri Lanka, and a person who aids and abets a person to commit suicide shall be punished with death. So that is still a very serious offense in Sri Lanka.
Exactly. So to assist is criminalized, but the act in itself and the attempt of the act is not. While I wish we had more time to get into the specifics relating to how and why suicide was considered as decriminalized and what those reforms led to, especially from a public policy health perspective, we have run out of time. Thank you so much, sir, for taking the time to try and grasp as much of this very vast area as much as possible to give us the best information to our laymen here today. Thank you very much for taking the time, sir.
Thank you.
All right, well, we'll leave you tonight with the words of Robert Kennedy. Every society gets the kind of criminal it deserves. Thank you very much for watching Law, Land and Liberty here on Other Than a News channel. Have a great night.